Question 371. A real property seller can recover damages from a real estate broker if the broker A. acts in excess of his authority conveyed by the seller, B. makes a representation to the buyer authorized by the seller, C. discloses a material fact to the buyer regarding the intended use of the property, D. provides revised escrow instructions to the property's escrow agent. Correct answer is A. acts in excess of his authority conveyed by the seller. A real estate broker acts as an agent for the seller, and their authority to act on the seller's behalf is defined by the listing agreement and any specific instructions provided. If a broker oversteps these boundaries and takes actions that were not authorized by the seller, and these unauthorized actions result in financial harm to the seller has grounds to seek recovery of damages from the broker. This could occur, for instance, if a broker disregards a seller's minimum acceptable price and enters into an agreement to sell the property for a lower amount without the seller's explicit consent. In such a scenario, the broker's actions exceed their authorized power and directly cause a financial loss to the seller, making the broker liable for those damages. Conversely, a seller would generally not have grounds to recover damages from a broker for actions taken within the scope of their authorized duties and legal obligations. For example, if a broker makes representations to a buyer that were specifically approved by the seller cannot later claim damages based on those statements, assuming the information provided was accurate. Similarly, a broker's duty to disclose material facts about the property to potential buyers is a fundamental aspect of real estate law and ethics. Disclosing information relevant to the intended use or condition of the property, even if it might influence the buyer's decision, is a protective measure for all parties involved and does not typically constitute grounds for a seller to sue their broker. Furthermore, a broker's involvement in the escrow process, including providing revised instructions to the escrow agent as the transaction progresses, is a standard and often necessary part of facilitating a real estate sale. As long as these instructions are made with the seller's knowledge or consent, or are reasonably necessary to complete the transaction according to the agreed-upon terms, they would not typically lead to liability for the broker. The key factor in determining a broker's liability for damages is whether their actions exceeded the authority granted by the seller and directly caused financial harm. Question 372. The State Attorney General's office would be legally required to become involved in which of the following cases? A. A real estate license applicant is accused of cheating on the licensing exam. B. A real estate developer is suspected of falsifying subdivision reports. C. A real estate broker whose license has been suspended sues to have the real estate commissioner's decision overturned. D. All of the above. Correct answer is D. All of the above. As the legal counsel for the Office of the Real Estate Commissioner, and by extension, the Bureau of Real Estate, the State Attorney General's office has a responsibility to represent the Commissioner's interests in various legal matters. This would indeed extend to all the scenarios listed. A real estate license applicant is accused of cheating on the licensing exam. The Attorney General's office could provide legal advice and representation to the Commissioner regarding the administrative proceedings and potential legal challenges arising from such accusations. B. A real estate developer is suspected of falsifying subdivision reports. This could lead to legal action initiated by the Commissioner or involve the Commissioner's office in investigations, requiring the Attorney General's legal counsel. C. A real estate broker whose license has been suspended sues to have the Real Estate Commissioner's decision overturned. When a state agency like the Bureau of Real Estate, CalBRE, formerly DRE, suspends a professional license, and the licensee challenges that decision in court, it typically involves a legal action against the state agency. The State Attorney General's office is the legal representative for state agencies in such lawsuits. Therefore, considering the Attorney General's role as the legal representative for the Real Estate Commissioner and the Bureau of Real Estate, they would be legally required to be involved in all of these cases to protect the Commissioner's interests and the enforcement of real estate law. Question 373. Which of the following is a recurring cost? A. Appraisal fee. B. Title insurance. C. Pest control. D. Recording fee. Correct answer is C. Pest control. Recurring costs are expenses that are paid on a regular basis, typically monthly, quarterly, or annually, throughout the period of ownership. Appraisal fee is a one-time cost paid at the beginning of a real estate transaction, usually when obtaining a loan. Title insurance is a one-time fee paid at the close of escrow to protect the buyer, and sometimes the lender, against future claims against the title. Pest control is not always monthly, but pest control services are often contracted on a recurring basis, e.g., quarterly or annually, to prevent or address pest infestations. Recording fee is a one-time fee paid to the county recorder's office to officially record the deed and other documents related to the property transfer. Therefore, pest control is the only option that represents a cost typically incurred on a recurring schedule after the initial purchase of the property. Question 374. The cost approach in appraisal relies on the following methods. A. Quantity survey method. B. Square foot method. C. Unit in place method. D. All of the above. Correct answer is D. All of the above. Quantity survey method involves breaking down the property into its component parts, materials, labor, overhead, and estimating the cost to rebuild it from scratch. Square foot method uses the cost per square foot to rebuild comparable properties to estimate the replacement cost of the subject property. Unit in place method assigns a cost per unit, e.g., per square foot of roof, per linear foot of plumbing, to various components of the property to estimate the replacement cost. Question 375. Prepaid rental listing agents are mandated to do the following, except A. Return the client fee if no referrals are submitted within 5 days of the agreement's execution. B. Provide a contract and receipt for every potential tenant, promising the return of their fee if certain circumstances are met. C. Submit an account statement to the real estate commissioner on a quarterly basis. D. Refund any funds over $25 if a rental is not procured. Correct answer is C. Submit an account statement to the real estate commissioner on a quarterly basis. Prepaid rental listing service, PRLS, agents in California have specific legal obligations to prospective tenants. They are required to provide a comprehensive written contract and a receipt for any fees collected. The contract must clearly state the services offered and the total fee. It must also specify the conditions for refunding any portion of the fee over $25 if the agent fails to find a suitable rental. This refund provision is a key consumer protection element within the regulations governing PRLS operations. Furthermore, PRLS agents are mandated to maintain thorough and accurate records of their business activities. These records must be readily available for inspection by the Bureau of Real Estate, CalBRE, at any time to ensure compliance with the law and to protect consumers from fraudulent or unethical practices. While agents must be prepared to account for the funds received and how their services are utilized, there is no specific legal requirement mandating the submission of a formal account statement directly to the real estate commissioner on a quarterly basis. PRLS agents are governed by regulations intended to protect prospective tenants. However, directly submitting a quarterly account statement to the real estate commissioner is not a required part of these regulations. Instead, the focus of the law is on the contractual agreement with the tenant, the provision of services, the refund mechanism for unsuccessful rental procurement, and the agent's obligation to maintain inspectable records. Question 376. In order to authorize a conventional loan, many lenders require an applicant to have A. Financing assistance from a friend or a relative for a down payment. B. 2 months or more of mortgage payments in reserve. C. A steady job with the possibility of advancement. D. 3 or more previously paid in full mortgage loans. Correct answer is B. 2 months or more of mortgage payments in reserve. Lenders often require borrowers to have a certain amount of funds in reserve, savings, checking, etc., in addition to the down payment and closing costs. These reserves act as a financial cushion to help the borrower continue making mortgage payments if they experience a temporary financial setback, such as job loss or unexpected expenses. 2 months of total housing expenses, including principal, interest, taxes, and insurance pity, is a common guideline. Borrowers with a higher amount of reserves are viewed as lower risks. Question 377. Blind ads are A. Set up so consumers who respond believe they will be speaking to the seller, only to be connected instead to the agent posting the ad. B. Designed to be accessible to sightless individuals. C. Illegal. D. Both A and C. Correct answer is D. Both A and C. Blind ads, in the realm of real estate, are a form of advertising designed to mislead the public into believing they are contacting a property seller directly, when in reality, the communication is being initiated and managed by a real estate agent. These advertisements typically omit the name of the real estate agent or brokerage, creating a false impression of direct seller contact. The intent behind such ads is often to generate leads for the agent, who can then attempt to represent the prospective buyer or secure a listing from the seller they indirectly contact. However, the practice of using blind ads is widely considered unethical and is, in fact, illegal in many jurisdictions, including California. Real estate advertising regulations are in place to ensure transparency and prevent deceptive practices. These regulations generally mandate that all real estate advertisements placed by licensed agents must clearly and prominently display the name of the agent and their employing brokerage. This requirement allows consumers to readily identify that they are engaging with a real estate professional and not a private seller, fostering a more honest and transparent marketplace. The prohibition of blind ads serves to protect the public from potentially misleading marketing tactics and upholds the principles of honesty and integrity within the real estate industry. These regulations aim to ensure that consumers are aware of whom they are communicating with from the outset, allowing them to make informed decisions about their real estate endeavors. Question 378. The authority to investigate non-licensees believed to be performing real estate activities for which a license is required is held by the A. Police, B. District Attorney, C. Real Estate Commissioner, D. State Legislature. Correct answer is C. Real Estate Commissioner. The primary responsibility for enforcing real estate license laws and protecting the public from unlicensed activity falls under the purview of the state's real estate regulatory body, headed by the Real Estate Commissioner, or a similar title. This agency has the specific authority and expertise to investigate individuals or entities suspected of engaging in real estate activities without the necessary licenses. The Real Estate Commissioner's Office is primarily responsible for investigating non-licensees suspected of performing real estate activities requiring a license. Although law enforcement agencies may become involved if additional illegal activities like fraud are suspected, the initial inquiry into unlicensed real estate practice falls under the Commissioner's authority. The state legislature establishes the laws and the Real Estate Commissioner's Office is tasked with enforcing those laws. Question 379. Ronald presented an offer to Joan to purchase her house, with the provision that Joan respond within a week of getting the offer. Joan was considering 2 other offers to buy her house, but ultimately decided to accept Ronald's offer. 9 days after she received it, Joan asked her broker to communicate her acceptance of Ronald's offer to him. In this situation, A. Ronald is obligated to go ahead with the purchase. B. Ronald is under no obligation to go ahead with the purchase because Joan did not personally tender her acceptance to Ronald. C. Ronald is obligated to present a counter-offer that provides another opportunity for Joan to accept it in a timely manner. D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. Correct answer is D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. Ronald's offer clearly stated that Joan needed to respond within 1 week of receiving the offer. This established a specific time limit for acceptance. Joan attempted to accept Ronald's offer 9 days after she received it, which is beyond the 1-week deadline stipulated in the offer. The offerer, Ronald in this case, has the right to specify the terms of acceptance, including the time frame. An acceptance that does not adhere to these terms is generally considered a rejection and a counteroffer. While Joan didn't personally tender the acceptance, communication through her broker would generally be considered valid, if the acceptance had been timely. The primary issue here is the lateness of the acceptance, not the method of communication. Ronald is not obligated because Joan's acceptance was outside the timeframe specified in his offer. Question 380. Types of real estate financing include the following. A. Assumptive. B. Equity. C. Debt. D. Both B and C. Correct answer is D. Both B and C. Debt financing is the most common type of real estate financing and involves borrowing money, creating debt, that must be repaid with interest over time. Examples include traditional mortgages, FHA loans, VA loans, and construction loans. Equity financing involves raising capital by selling an ownership stake in the property or project to investors. The investors then share in the potential profits or appreciation of the real estate. Examples include partnerships, joint ventures, and real estate investment trusts, REITs. An assumable mortgage is a feature of certain types of debt financing, primarily government-backed loans like FHA, VA, and USDA. It allows a buyer to take over the seller's existing mortgage, including its terms and interest rate. It's not a fundamental category of financing like debt or equity. Therefore, the main categories of real estate financing are based on whether the capital is obtained through borrowing, debt, or by giving up ownership, equity.